at 27 minutes before 11 o'clock. Thank you for tuning in this Wednesday morning, and it is time for Legally Yours. This is the show hosted by John B. Fuller. He is an attorney at the law firm of Fuller & Fuller here in Ocala, and this is a good time for you to call to ask your legal question. Get some advice from John during the course of the show. You need to know what date it is so that you know whether this is a rebroadcast or not. Today's date is Wednesday, February 26, 2014. If your calendar shows the same date, then you're listening to a live broadcast, and the number to call in is 622-9622. 622-WOCA is the WOCA Climate Control Source Hotline. Good morning, John.
Good morning, Larry. How have you been?
Pretty good.
I'm glad to be back. The last two Wednesdays, I've had scheduled conflicts with court cases, and so I've been unable to be here, and I've missed you and our listeners. And on this rainy Wednesday, I'm happy to be back and chat with you. And if anyone's listening and have questions about a legal issue or the legal system that we can help them with in general terms at this time, that's what we want to do. Obviously, if it's about a specific case, I always tell folks they need to make an appointment or see a specialist in a particular area, and so that your individual problem or issue can be addressed and appropriately dealt with. But other than that, it's always fun to be here and enjoy and appreciate all our listeners. Although many people may have gotten out of the habit because it's been 2 weeks since we've had a call-in show.
That's right. So just to remind you, today is February 26, 2014. You can call in if you'd like. I responded to my subpoena to serve jury duty on Monday.
Well, congratulations, and to you for fulfilling your civic responsibility. I'm always interested when folks do that. Did you get picked to serve?
No, I did not.
Okay. Were you called into the jury box and questioned during what's called voir dire?
No, but I learned about that from the video that they showed.
Okay.
Yeah.
All right.
Yeah.
So you were there in the jury assembly room. Were you sent up to a courtroom?
No, sir. No, my experience was just to sit there until just about lunchtime, and they told us that they didn't need anybody. And it sounded like a rock concert ended. Everybody cheered. Yay, we go home.
Well, everybody understands that jury duty is a duty, and it's an imposition on people's lives. But the system won't work without it. And if you, God forbid, were in a major case where you had been hurt,
right,
and
right,
you wanted to have a determination of what the fair value of your damages were, you would want conscientious jurors who were there with open minds, who were willing to serve as part of their civic duty, their duties of citizenship, if you will. You have two duties as a citizen: vote and jury duty, and that's what preserves our system.
Well, I was hearing your voice in my head as I went there, because I was thinking maybe I can weasel my way out of this. I knew you'd be disappointed in me for that thought, but as I said, when I parked the car in the courthouse parking lot, I said a prayer, and I said, okay, I'm not going to pray for you to get me out of this, because I think you know better than me. There might be somebody in there that needs my insight. Maybe somebody's innocent and they need to have me on that jury. So I said, all right, I'll go in. I'll do whatever I need to do. So, but they didn't need me after all. So
well, and you know, they never know how many cases they're going to have, how many cases are going to be settled at the last minute, how many cases may be continued at the last minute,
right.
And so they always call more. Try to call more than they need. Sometimes they don't, and that's an interesting little side note in our legal system. If you're picking a jury in a case, and you have the people called into the box, and they're excused for cause, and then they're excused for peremptory challenges, which are just you don't have to have a justification for it, absent certain individual specific cases, and they run out of jurors. They have the right under the law for the judge to send the bailiff out on the street and to grab people and summons, not grab them literally, but
No
to summons
way.
them off the street and bring them into jury duty
wow.
in order to avoid having a mistrial.
Holy mackerel! I'm not going to walk near the courthouse anymore.
Yeah, no, I've had cases. I've had cases where it's taken 3, 4, 5 days to pick a jury because there was so many peremptory challenges.
Wow.
You have generally 3 peremptory challenges. We have a call, so
Yes,
let's
sir.
move on.
We do. Good morning. Thank you for calling. You're on there with John Fuller.
Yes, good morning, Mr. Fuller.
Good morning. How are you, sir?
Very good, thank you. Glad to see the rain again.
Yeah.
Not the weekend. I had the privilege of serving twice on jury service duty, and I was called both times to the case, and I was very proud to be there, and it was very interesting. And it was both cases were with Judge Futch, that has now retired, wonderful person. And in the mail, about a week or two after I served on both those juries, I've got a certificate of jury service in the mail with a gold C seal on it, and I very proudly framed them, and I've got them in my family room. And whenever I have company, I'm more than glad to explain exactly what they are, and I'm very proud of serving on the jury.
Well, that's great. That's like I was talking with Larry. The system simply won't function, and when you give your time, make the sacrifice to do jury service, you should just keep in mind that at some point it could be you or your family that need open-minded, unbiased citizens who are willing to make the sacrifices from their jobs, their families, or what have you, to serve on a jury. And most juries, most trials, fortunately, are concluded in several days or a week at most. They are some cases that are exceedingly complex and far-reaching that take much longer than that. And of course, those are huge impositions on people. Sometimes in very high-profile cases, the court will feel that the only way to prevent a jury from being contaminated by information that is not being presented to it in proper evidentiary form in the courtroom to preserve the integrity of the jury, they will sequester the jury. I'm sure you've seen that on television in high-profile cases, and that's certainly a burden, but it's a necessary and essential obligation of citizenship. I was called to serve on a jury a number of years ago, and went, and I thought, I could get out of this simply because of the type of work I do. And I thought, that would be pretty hypocritical for me to expect citizens to come try my cases and hear my cases. And so I went over, and I thought, because of my background as an attorney, that I would not be chosen if I was even called into the box. And that's kind of a random element. They pick the numbers out of a box, and that gets you into what they call the jury box. They have a little box that holds the numbers of each juror. And you get called in, then you go through where the lawyers get to ask you some questions to find out if you are a juror who's suitable for that case. And if you get challenged and excused, I don't want people on juries to think that that's an insult to them or an affront to them or a rejection of them. Some people are just not suitable for a particular case, and they could be the best juror in the world for another case. But if you were trying a criminal case, for instance, and you or your family had been the victim of a crime, you may not be able to be completely unbiased and open-minded about that. So you would very likely be dismissed by one of the lawyers or maybe even the judge for cause in a case like that. But you could come back the next day or that afternoon in another courtroom in another case that was an automobile accident case, and be perfectly, and they'd be delighted to have you serve as a juror. So if you're not chosen, don't be offended by that, and don't take that personally, because it is certainly not a reflection on any individual's integrity or their honor or their abilities.
Right. Thank you very much. The real reason I called was I have a question on when you bond somebody out of jail, and they eventually go in front of the judge. When are you repaid your bond, and do you get all your money back, or can some of that money be removed and taken down somehow?
Well, that's a good question, and let's define some terms. So we're talking apples and apples instead of apples and oranges. Pretrial release takes the form of bail. Bail is an amount of money that the defendant or his friends or family would post a cash amount, would pay a cash amount into the registry of the court, and that cash amount would sit there, doesn't draw any interest, it just sits there, and when the accused person who has been released on pretrial bail, where there is a cash payment for the bail, when that person appears for the final hearing, the final trial, and the case is ultimately disposed of, if that person has appeared and has not become a fugitive and run away, then the bail money is released and paid back to whomever paid the bail into the court system for that person's pretrial release. That's pretrial bail. And if the individual who's charged shows up at all the hearings, goes through the case, and the case is concluded, whether there's an adjudication of guilt and the person is sent to jail, or there's a not guilty by the jury and he is released, then the money is paid back. If however, if I may just go on so the point is complete and our listeners understand the full thing, if you use a bail bondsman, that is a bond. That is like buying an insurance policy. You go to a commercial bail bondsman who's licensed to write bonds, and they will pledge their security and money if the person fails to appear. And you have to pay them 10% of the value of the bail. You never get that 10% back. If the person doesn't appear, if he becomes a fugitive and does not appear for the trial of the case, then the bail bondsman, let's say the bond is $50,000. The bail is $50,000. You go to a bail bondsman, you have to pay him $5,000, and then he's responsible to pay $50,000 to the court if the person who's charged doesn't show up as he's supposed to. If he shows up and he's found not guilty or whatever the disposition is, when the case is all over, the surety, the bondsman, is released from any further obligation on that case, and he keeps his $5,000 that he's been paid as a premium, just like you'd pay premium on an insurance policy, and the person has been out of jail all that time. A lot of people don't have $50,000 cash sitting around, but they still have $5,000 cash, and they can get out, and it may be 6 months or more before that case comes to trial. And they have a job, they have a family, they can go about their lives while the case is pending, and so that's how that works. But there's a difference between bond and bail.
Okay, very good. Thank you very much.
Okay, my pleasure. That was a great question.
And I've never understood it, so thank you for helping me understand that.
That's okay. A lot of people don't understand it. And a lot of times there are a lot of other conditions to pretrial release other than paying bail or posting a bond with a bail bondsman, such as a curfew, such as staying away from the alleged victim, such as a prohibition against possessing firearms or imbibing alcoholic beverages, a requirement not to travel outside of Marion County, to surrender your passport. They can put all kinds of conditions on pretrial release.
Wow. Now, in the juror thing, the little video that we watched, it said that if you are picked, you can't go to the scene of the crime, you can't do this, that, you can't tell your spouse about what's going on, and it said you can't speak to the media.
Right.
So I thought, well, wait a minute, then they can't even consider me, because I am the media.
Well, that's your job, but when you're a juror, you're not the media. Other than that,
Oh, really?
your
Okay.
job. But what it means is you couldn't come to you couldn't during the time that you were serving on a jury, you couldn't call up Robin and say, "Hey, I'm serving as a juror on this really interesting case. Let me,
Then I'll have a
you
case."
can't. And they just had, and this is very critical and important. They just had a murder case that was tried before Judge Lambert, I think last week, maybe week before last, that was being tried for the second time. And the case had been tried for a number of days, and that's expensive, and that's taxpayer dollars that pays the bailiff, pays the juror, the witness fee, or pays the juror fees, pays for the court reporter, the courtroom, the electrical lights, the bailiff, the clerk. It's an expensive process for the trial to take place. And during the first trial, after several days, after repetitive admonishment at the video they show when you walk in the jury assembly room, to what the judge instructs under the standard jury instructions that he gives the jurors at the beginning of every trial, at the end of every trial day, he inquires. And one of the jurors in that trial took it upon himself after a number of days to go do independent research on the definition of some of the legal terms. And when that was announced to the bailiff by one of the other jurors, Judge Lambert had no choice but to declare a mistrial, send all those people home, because one juror failed to comply with clear, repetitive instructions, and that's inappropriate, and it's a wasteful, and it's costing the taxpayers of Marion County unnecessary money. So it's important that you abide by and comply with these rules scrupulously.
But why would the court system not want a juror to understand the definition of a word?
The definitions that the jurors need to know are provided to them in the instructions that are given to them by the judge at the end of the trial. And they should not do independent research.
Just on the definition of a word?
Sir? Yeah.
He got in trouble for I don't know if it was he or she.
I don't remember exactly what it was. It was a couple of months ago in the paper. I don't know whether he went by, but he Googled something like probable cause or presumption of innocence. I really don't remember. So don't anybody take offense if I misstate it. But it was one of the essential elements that only the judge explains that to jurors. That's the judge's job, is to explain the law. The judge determines the legal elements that from the law and explains it to the jury. The jury then determines the facts. Do these facts, how do they apply to this case based upon these legal principles that the judge has instructed us on?
So you, as an attorney, you have to be keenly aware of what that jury is doing.
Oh, well, the judge also, and that's why they have bailiffs. When they go to lunch, they wear jury pins, and a deputy sheriff accompanies them, takes them to the restaurant for lunch. They eat together, and they come back. They are instructed by the judge at the beginning of every case, civil or criminal. You are now sworn as a member of the jury of this case. During your jury service, you are not to discuss any aspect of this case. Do not read the news media. Do not discuss it even with your spouse. If someone approaches you and even begins to talk, you're to immediately advise them that you are on a jury, that you've been impaneled to serve as a juror, and that you cannot talk with them about anything, and please do not continue. If they do continue, report it immediately to me, and I will take care of it.
And that seems to explain why a public sentiment seems to be exactly opposite of what a jury determines in the O.J. Simpson case and in the Zimmerman case. And
absolutely. I tried a case in 2007 or 8 that was a high-profile criminal defense case, and I don't want to be critical critical of my friends in the press because Mark Twain said it's not a very bright person who gets into an argument with people that buy ink by the barrel. So I never want to overtly criticize. But what was being reported and the way it was being reported and what was unfolding in the courtroom, there was a huge disconnect. And part of the problem is, I'm sure people in the media do the best job that they can, but they can't be everywhere at once. So you come into a trial and sit down and spend an hour and a half in an 8-hour trial day. I've been trying cases for 40 years. I don't know how many jury trials I've had, so civil and criminal together, probably 100. And I could not begin to put together what was going on in that courtroom in a case that I sat down in for 1 hour out of an 8-hour day, and I came in morning and afternoon.
Good point,
and,
yeah.
And then I have to write an article about what's going on.
Right, that's a really good point.
And they can read what the police officers may be saying, what the police report may be saying, but those things aren't evidence unless the judge lets the jury hear it. And law enforcement officers may say things publicly that contains hearsay, that has a lot of evidence or information that is not admissible as evidence. Our rules of evidence are to make sure that the facts that the jury hear are relevant, material, non-prejudicial or inflammatory, and reliable. And that's why we have the hearsay rule, because our judicial system has determined that hearsay evidence is inherently unreliable. It has to be something that you saw or you heard in the way of not somebody telling you. Hearsay is defined as an out-of-court declaration, not in the presence of the party to whom it's offered against, of a relevant material element.
Wow, that was almost as complicated as that black hole conversation we had.
Sorry.
The phone number, if you have a question for John, is 622-9622. Remember, we are live on Wednesday, February 26th. So if your calendar shows that date, that means you're listening to a live show. It's a good opportunity to call to get some insight from John about a legal situation you might be in or somebody you know. 622-9622 is the number. Wow, it sounds so exciting. Once I made up my mind that I'm going to do this. If I'm needed, I'm going to answer to the call, whatever. Then I was anxious about it. I was looking forward to it.
Well, I agree with you. And even though I had tried a lot of cases at the time, and this has been 20 plus years ago when I received a summons for jury duty, and I was ultimately chosen and did serve on a jury and did hear the case from start to finish. And it was a wonderful educational experience. I wouldn't take anything
even with your education.
Absolutely,
Wow.
absolutely. Wow. You never ever, as a lawyer, you have no idea how things look through the eyes of a juror. You have no idea what's going to be important to a jury when they go back to deliberate, or how they're going to approach the issues. And I learned an awful lot about trying cases. I try to be thorough in my voir dire, and I had always made it a practice when I was talking to jurors and they're sitting there next to each other. I would ask them, I said, folks, do any of you know each other that are sitting up here in the jury box? Because if they do, I want to know what their relationship is, because I want everybody to have their own independent thought,
right,
and not be in a
right.
position where they may be dominated by somebody.
True, yeah.
And in this particular case, neither one of the lawyers asked that question, and it happened that one of the ladies that served on the jury with me had known me since I was about 12 years old. And it did not affect our deliberation, but it would be a question that you
So
would
your
want to know.
experience gave you insight as to one question that needed to be asked.
Well, it reaffirmed that was
Right.
a good question, and,
Right.
and I've
Yeah.
asked that question to every jury that I have ever picked over my entire career, and I've never had anybody say, "Oh yeah, the guy sitting down front, he's my next door neighbor, or he's married to my cousin, or anything
Never,
like
huh?
that." Never had anybody say anything, and I'm sitting there in the jury box while they're asking all these questions, and we're just answering the questions, and nobody asked, "Do you know anybody?" And this lady I had known since I was in grade school.
So it didn't matter that you were studying law, or you were already an attorney.
I was already
right?
practicing law. I probably practiced law 10 years at that point.
So would it have mattered, and my brother told me that it might have, would it have mattered if, my dad was a policeman, my nephew was a corrections officer, my brother was a police officer? Would that have mattered?
Well, it depends on the case.
Okay.
If they're going to be witnesses who are law enforcement officers, and you and your family have a long history of personal involvement with law enforcement, the question is, do you think that maybe even subconsciously you would tend to give more weight and credibility to testimony that was offered by a law enforcement officer simply because he's in law enforcement and you have a long history of law enforcement involvement in your family, so that you would weigh that testimony and give it more credibility than you would from a witness who was not a law enforcement officer? Because one of the instructions from the court is that you are to keep an open mind throughout the trial, to listen to all of the evidence and weigh it all fairly and equally, and then only make up your mind after the case is all over and you go back to the jury room with your other fellow jurors to start deliberating.
Wow. Well, the fact that you were not here the last couple of weeks, I was so anxious to tell you that I was being called for jury duty. So this is an opportunity to speak
One quick thing about picking a jury. There is one exception to the peremptory challenge. Peremptory just means you can dismiss anybody that you want without having to give a reason. But if the person you seek to dismiss is a member of a minority class, and the other side wishes to challenge it, there is a case called the Reed case and the Reed challenge, where they can say, Your Honor, this person is being excused for a peremptory, meaning no explanation for why.
Right.
That person is a member of a minority. I am challenging the other lawyer to explain a justification other than racial prejudice in trying to keep a minority off. And then you've got to come back and have a justifiable reason. You just gave a great one. If I was going to excuse someone on a peremptory challenge, and they happened to be a member of an ethnic minority, and it was challenged, and they were like you. My father was in law enforcement. My brother was a corrections officer. My mother was a bailiff. My son is studying to be a law enforcement officer. I would say it has nothing to do with the fact that you're blonde or you're a member of a minority or what have you. I am concerned because this individual has a long history of close involvement with law enforcement. And then the burden would shift back to show that wasn't a valid reason, and that is a valid reason.
Wow. It's always fascinating, and it always goes too quick. And
it's fun to be back.
Appreciate learning from you, John. All right, so how do we get a hold of you?
Our office number is 352-547-4292. Our toll-free number is 855-534-2565. And we do have offices in Ocala and the Villages. If you have a legal case where you've been hurt in an automobile accident, business or commercial, or a Social Security disability claim, call us. We'd be glad to help you.
John, thank you so much.
Thank you, Larry. It's great to be back.
Good show. We'll take a little break, and we'll be right back.
Ocala's information station, 1370 WOCA.
Ocala. ABC